Well, as I said, I'm not a breaking news channel, and I read this. I read this when it came out, like literally right after it came out. I read this and I recorded it, but I was already working on another video. And oh, I should move over here. I was already working on the other video, and I thought I would combine them, and then it was just way too long, so I split them apart. And then, wouldn't you know it, before I even finished editing this video, the order came out. So basically, Judge Lyman granted the order to stay discovery in favor of the New York Times. I was listening to it, and then I thought, you know what, let me just jump on and just say that the letter is already kind of pointless. But he did say that he thinks that the Wayfarer parties will have to submit an amended complaint talking more in depth about the discovery that they want from the New York Times. So maybe I will just let the AI voice that I listen to on naturalreaders.com play it. So at least you can hear it. I'll put it at the end of the video after I read the letter that was basically denied. Watch
Follow them
Alita,
all.
who I watch. Alita Legal Bites, Natalie Lawyer Chick, Emily D. Baker, Lawyer Lee, and last but never least, Peter Tragos, Lawyer You Know. Follow them all, who I watch. All right, this is a letter to the judge from Justin's lawyers, Bryan Freedman.
catlovedreamingpeach.com.
Fucking crook. Anyway, I have been following Court Listener. I'll pop this up. I've been getting updates, email updates when something is. Oh, I'm just going to turn this light on so make it look nicer. Oh well. It took a while for me to realize that. So there's a new docket entry, okay, for their case. And I'm going to read it, but I'm not going to read it from there because I actually downloaded it. All right, this is a letter to the judge from Justin's lawyers, Bryan Freedman, Mitchell Schuster, and Kevin Fritz. So I don't even know what this says, but I thought I might as well take a look at it, see what it says before I finish my video. Maybe there's something interesting here that I can add to the video. So let me get it sized better. Okay, so this is case 124 CV 149-LJL, document 117, filed today. Up here you can see the date. It's Monday, March 3rd. This is Eastern Standard Time, so it's 7:49 p.m. right now. This was filed today. This is 4 pages. It's from Mitchell Schuster at Meister, Seelig and Fine PLLC, which is a law office, via electronic something filing, I'm guessing. Electronic court filing? Honorable Louis Judge Lyman, or J. Lyman, United States District Court, Southern District of New York, 500 Pearl Street, room 1620, New York, New York, 10007. Lively versus Wayfarer Studios LLC et al. Number 124 CV. I already read that. And The related Wayfarer Studios LLC et al. V. Lively et al. 125. Dear Judge Lyman, can you see it? Maybe I can zoom in a little bit more. Let's see if I close that. Hide the sidebar. Sidebar. Scooch it over just a little more. Oh. Dear Judge Lyman, as counsel for Wayfarer Studios LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie LLC, Melissa Nathan, The Agency Group PR LLC, and this bitch needs to be dropped. Jennifer Abel, who said really nasty things about Justin. Collectively, the Wayfarer parties, we object to the New York Times Company's, The Times, request for an order pursuant to Federal Rule of Civil Procedure 26C, staying discovery as to The Times, pending a determination of its motion to dismiss the Wayfarer parties, amended complaint, docket 109. Pursuant to Rule 26C, the court has discretion to issue a protective order on matters relating to discovery upon showing of, quote, good cause. See Federal R Civil P 26C1 Hung Leon Finn Ltd versus Pinnacle Performance Ltd FRD 6972 SDNY 2013. Quote, the burden of showing good cause for the issuance of a protective order falls on the party seeking the order. End quote. Republic of Turkey v. Christie's, Inc., 2016 F Sup 3D 675, some more numbers and stuff from 2018. Quote, to establish good cause under Rule 26C, courts require a particular and specific demonstration of fact as distinguished from stereotyped and conclusory statements, i.d. internal quotations omitted. Quote, discovery should not be routine. Quote, discovery should not be routinely stayed simply on the basis that a motion to dismiss has been filed. Moran v. Flaherty, number 92, CV 3200, 1992, WL, stuff, 1992. See also Usab L. Lazar, numbers from 2013, more numbers, June 25th, 2013, rejecting contention that, quote, discovery must automatically be stayed pending a motion to dismiss, end quote. Quote, a court determining whether to grant a stay of discovery pending a motion must look to the particular circumstances and posture of each use, end quote. Republic of Turkey 316, numbers, quote, court should consider multiple factors, including the breadth of discovery sought, the burden of responding to it, the prejudice that would result to the party opposing the stay, and the strength of the pending motion forming the basis of the request for the stay. ID, quoting Country Club of Fairfield Inc. versus NH Insurance, the case number 2014. What is granting a stay in a legal case? Granting a stay in a legal case means that a court has issued an order to temporarily halt or suspend further proceedings in a case, essentially putting the legal process on hold until further notice. This is often done while an appeal is pending to allow the appellate court to review the case without the lower court's decision being enforced immediately. Key points about a stay. Purpose. A stay is used to prevent immediate action on a court decision, allowing time for further legal steps like appeals or addressing specific issues before the case fully proceeds. When it might be granted, a judge may grant a stay if a party demonstrates potential for significant harm, if the decision is enforced immediately, or if there are unresolved legal issues that need to be addressed before moving forward. Okay, so let's continue. So I have alerts set, so when new documents drop, I get them. A court determining whether to grant a stay of discovery. Oh wait, I was over here. Okay, and the strength of the pending motion forming the basis of the request for stay. This is from August 8th, 2014. None of these factors weigh in favor of staying discovery as to the times. First, the Times has not demonstrated that the discovery sought from it will be voluminous or burdensome. The Times allegation that, quote, discovery in this case is likely to be far-reaching, expensive, and wrought with complications, end quote, is based upon pure speculation. Docket 109, page 3. Indeed, no discovery demands have even been served upon the Times by any party to this action. Furthermore, to the extent that the Times is concerned about requests for, quote, call logs and other extensive discovery, we note that such overly intrusive, quote, overly intrusive discovery was sought by the lively parties, not the wayfarer parties, motherfucker. Yet again, the double standards never stop. And this court, in granting the Wayfarer party's recent motion to quash certain subpoenas, advised the lively parties on how to appropriately narrow their discovery requests, docket 102. In any event, given that Miss Lively alleges that the purported negative media campaign did not begin until approximately August 24, 2024, docket 84, 23, 26, 27, 28, coupled with the fact that the Times' article concerning the alleged, quote, smear campaign was published in December 2024, docket 50, paragraph 261, the relevant period for any discovery sought from the Times is extremely narrow, thereby undermining any claim of burdensomeness. The Times' argument that it should not be compelled to litigate, quote, complicated issues relating to discovery is unavailing.
Unavailing.
Achieving little or nothing, ineffective. The Times' argument that it should not be compelled to litigate, quote, complicated issues, end quote, relating to discovery is unavailing. Docket 109, page 3. If that was the standard, then virtually no discovery would proceed in any case with a pending motion to dismiss. See Brower v. Egan Jones Ratings Co. blah, 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 blah. Denying stay of discovery pending motion to dismiss because, quote, some burden exists in all discovery, end quote. Moreover, even if the Wayfarer parties' claims against the Times are dismissed, which is unlikely, the Times will remain a critical precipient witness as it relates to the other claims herein and will, accordingly, remain subject to similar discovery obligations as a non-party. CID. Identifying stay of discovery because, quote, it is inevitable that some discovery may be obtained from defendant regardless of the outcome of her motion, end quote, to dismiss. Bennett v. Cuomo, and there's the number from February 15th, 2023. Denying stay of discovery because burdens thereof, quote, are unlikely to change substantially regardless of how the motions to dismiss are decided, end quote, given that movants, quote, will remain key witnesses even if the claims against them are dismissed, end quote. In sum, the Times' conclusory allegations are insufficient to establish that it will be unduly burdened by discovery. My arms, I need to stretch. So that's why I move my arms around, by the way. See Mira v. Jordan. There's the case number 2026, March 1st of 2026. Denying stay of discovery pending motion to dismiss, where defendant, quote, did not explain why, end quote, plaintiff's discovery demands are, quote, voluminous and burdensome, end quote, and did, quote, not identify any burden associated with the production, end quote. Denying stay of discovery pending motion to dismiss, where defendant did not explain why plaintiff's discovery demands are voluminous and burdensome, and did not identify any burden associated with the production. Second, the Times has failed to establish that the wayfarer parties will not be unfairly prejudiced by their request for a stay. While the Times contends that the requested stay is, quote, for a, quote, short period of time, end quote, docket 109, page 3, the Times cannot predict when the court will decide the motion to dismiss. Most likely, a stay of discovery as to the Times will significantly disrupt the deadlines set forth in the case management plan and scheduling order, docket 58. As it stands, fact discovery is scheduled to be completed by August 15th, 2025, less than 6 months from the date of this letter. Even assuming the wayfarer parties are not unfairly prejudiced by a stay, meaning you can't have the stuff you need, that alone is insufficient to stay discovery given the other factors weighing against a stay. See Brower case. Third, the Times has not made a, quote, strong showing, end quote, that the wayfarer parties' claims are unmeritorious. As part of the merits analysis, quote, courts have also considered whether a pending motion to dismiss will dispose of the whole action. Bennett 2023, numbers CT Espresso LLC v. Lavazza Premium Coffees Corp., numbers May 24th, 2024, page 3 of 4. Quote, on the first factor of the merits of plaintiff's claims, courts tend to consider whether the resolution of the pending motion to dismiss may dispose of the entire action, end quote, internal quotation omitted. Here, other than the Times, there are dozens of parties who will remain parties, and the wayfarer parties do not presently intend to move to dismiss Miss Lively's claims. I'll say that again. Here, other than the Times, there are dozens of parties who will remain parties, and the wayfarer parties do not presently intend to move to dismiss Miss Lively's claims. Therefore, the Times' motion to dismiss will not dispose of the whole action. Additionally, when, quote, when an assessment of the merits of a plaintiff's claims involve a fact-intensive analysis, such as choice of law assessment, courts have declined to conclude that a plaintiff's claims are unmeritorious. Bennett 2023 and some numbers. Miss Lively's amended complaint contends that California law applies to her claims against the wayfarer parties, docket 84, paragraph 68, 375 to 417. The wayfarer parties' claims, including against the Times, are asserted under California law, docket 50, page 211, number 27. In its motion to dismiss, the Times contends that New York law applies to the claims against it and concedes that, quote, the laws of California and New York conflict, end quote. For some of the claims, docket 106, page 6, given the choice of law analysis the court must undertake to decide the dismissal motion, The court should decline to stay discovery for this reason alone. C. Morales v. Next Stop 2006, Inc. There's the case number, October 27th, 2022. Denying stay of discovery because court could not, quote, conclude that defendants have substantial arguments for dismissal given defendants' motion to dismiss invoke choice of law principles, Mira v. Jordan, 2026, at 2. Denying stay of discovery where parties disputed which state law governed defamation claim. Even if New York law were determined to apply to the defamation claim, the court cannot determine as a matter of law that the state's fair report privilege applies because, quote, it is for the jury to decide if the context in which the statements are made makes it impossible for the ordinary viewer or reader to determine whether the publication was reporting on a if the context in which the statements are made makes it impossible for the ordinary reader or viewer to determine whether the publication was reporting on a judicial proceeding, end quote. Shaindlin v. Brady. There's the case from 2022. Lyman J. Did they throw in his own case? Quoting Kinsey v. New York Times. Oh my God, did they literally quote a Judge Lyman case against the New York Times? Second Circuit 2021. Although the Times argues that its article merely, quote, reports Blake Lively's California Civil Rights Department complaint against Justin Baldoni and others, and thus purportedly, quote, is absolutely protected under New York's fair report privilege, docket 109, page 2. The Times' dismissal motion acknowledges that the article went beyond reporting. Quote, here, the article lays out in great detail the factual basis for its conclusion that plaintiffs engaged in a smear campaign, a quote, smear campaign, against Blake Lively, docket 106, page 19, emphasis added. The amended complaint thoroughly alleges why the article is not a substantially accurate summary of the administrative complaint. Docket 50 is the second paragraph, 261 to 299. See Carides v. Ackerley Group, Inc. There's the case, 2005. Vacating order granting motion to dismiss where reasonable jury could find that news articles suggested more serious conduct than actually suggested in official proceedings, and that article was not substantially accurate. They lied and said that it was based on a complaint that hadn't even happened yet, and they had been planning the article possibly for months, long before, and they published it before she actually ever made a complaint, or they held on to it until right after she made the complaint, and then they dropped it. Either way, they're fucking shady as fuck. They are the smear campaign. For good measure, the Wayfarer parties intend to seek leave to amend their pleadings to remedy any defects therein that might otherwise support the Times' motion to dismiss, such as impermissible group pleading, which weighs against a stay of discovery. See Moran v. Flattery, 1992. In reference, Chase Manhattan Corp. Sick litigant, and there's a case number from May 7th, 1991. Scrolling up. We respectfully request that the court deny the Times' motion for a stay of discovery. At a minimum, document discovery with the Times should proceed, and the court should stay that party's deposition only pending its motion to dismiss. See and there's another case from 1996. Respectfully, Mitchell Schuster from Meister, Selig, and Feen, and Linner, Freedman, Tate, Stolman and Cooley LLP, Bryan Freedman, Miles Cooley, Teresa Troopson, Summer Benson, Jason Sunshine. What? Oh, yeah, we already talked about that. If they get married, she could be Summer Sunshine. Okay, so that's that document. So let me see. So no new documents dropped. All right. So, well, my last thoughts about it. Yeah, I mean, the Times has to hand over. So they basically want to be able to prove that the Times was working in cahoots, in conjunction, uh, you know, uh, in defamation of Justin Baldoni. And they never came to ask him his side. They never really investigated, similarly to Sony. And um allegedly, and they really are trying to smear him and destroy him and to have double standards in every single issue. And hopefully the judge will not allow that, and that the judge will hold the law. And oh, so before I forget, I guess I'm coming to the end of the video. The reason I stopped following Daily Dose of Donna is because I was on her stream one day, and oh, that reminds me of a couple of pictures I wanted to show. So she started to talk about Liz Plank, who I also can't stand because Liz Plank is a fake skank. She's a backstabbing, two-timing sellout. And Daily Dose of Donna was saying, well, I have a friend who was friends with Liz Plank, and Liz Plank had said, "Free Palestine." And then Donna said, "You just can't be friends with people like that," which I personally find reprehensible. Now, I think that Liz Plank is reprehensible, but not for that. Then a lot of people started to write "Free Palestine, Free Palestine, Free Palestine" in the comments. And Daily Dose of Donna, bitch, said, "Mods, I want you to delete those comments and block every single person who's saying that." Then after a few minutes of that, she was like, "Yay, I'm so glad to see you guys being blocked." Then after they were blocked, and I was just sitting there, like I was literally about to type "Free Palestine," and I was just frozen, like, I cannot believe this is happening. Then after she was like, "Okay, great, you're all blocked," she said, "It's not like I'm not willing to have a conversation. I mean, I'm willing to have a conversation. It's not like I don't care about Palestinian people, but oh no, you are not going to get on my channel and say, free Palestine. Absolutely not." And I just was like, I'm not writing my comment. I'm immediately unfollowing. I'm not even going to bother wasting my breath saying I unfollow, because like they always say, you don't need to announce your departure. If you want to unfollow somebody, you can unfollow. So that's why I don't follow her. Then Dave Neal, I followed him for about a week or two. And anyway, she had been so problematic. Like I followed her for like 3 weeks, and every video I was like, what is she talking about? Why is she saying this? So it tracked. Then Dave Neal, he's a comedian. I was following him. I unfollowed him because I felt like, well, there was too many times where he was like talking about how pretty Blake Lively is, and I'm like, this bitch has falsely accused a man of some horrific shit. She's literally trying to destroy this man's life. And you want to talk about how pretty she is. This fucking 3-time nose job, eye plastic surgery, like she's got a fucking spray tan or whatever the hell it is. She wears wigs and extensions all the time. She's had lip filler. God knows what else. She probably had like nips and tucks and shit. And why does that matter? Why does it matter? Because she is an evil person who bought a fake look, and you want to fawn over how pretty she is when she is trying to destroy someone? No. Then the last straw for me was he did a whole video about basically talking about giving Blake Lively grace, bitch. And I commented, It's one thing to give somebody grace. You say you're neutral, Dave, but you have been bending over backwards every single day, video after video, bending over backwards to find any way you possibly can to excuse this behavior. Then he blamed it on postpartum depression. Like, oh, now you're weaponizing motherhood to say that a woman who just gave birth could be a despicable, vile person. Like, I was like, fuck this bitch. Unfollow, hard as fuck unfollow on him. Okay. Next up, who I might unfollow will be Zach Peters, because he's friends with them. And I'm like, no, fuck that bitch. Okay. But so far, I'm following him to see what he's saying. And then, so basically, who I am I actually gonna follow when it comes to this case? As always, Alita, Legal Bites. She's a lawyer, so her perspective is an actual neutral legal perspective, not some biased bullshit. Oh, she's so uniquely and beautiful. What? She's as plain Jane as they come, and her fake wigs it looks stupid, okay? And her mole disgusts me. I know that's rude and mean. Some people like moles or whatever. I personally, I get grossed out by moles. So her mole is extra gross because it's filled with vile evilness. Candace Owens. Ah, look right here. Do I need to say more? No. She's a fucking whack. She's a Kanye, female Kanye. Something fucking weird. She's very fucking bizarre. I'm not about it. No. So I don't care if she's latched on to this story. That's what I'm saying. Like, just because the story is interesting and intriguing to me doesn't mean that I want to hear everybody's opinion on it. I listened to Donna for a little while, when she was like, Taylor Swift was a real friend and she's going to stick by her. Like, what? No, you don't. No, you do not stick by. It's not a real friend when somebody betrays you and uses you and fucking says you're their dragon, and then you're not okay with that, and then you're supposed to stick by them. Like, ugh, toxic. And then you don't believe Palestinians are people, I guess. That's very toxic to me. I don't do Zion. I don't fuck with Zionists. No. Mm-mm. So, if you're a Zionist and you're I don't know, you can fuck off too. MAGA can fuck off. Zionists, you can fuck off. And people who think that men can't be victims, you can fuck off. People who think that blonde, fucking fake blonde, white woman tears matter more than an actual man of integrity. Again, I believe he's a man of integrity. He may have poor judgment. He may have poor taste. I mean, I don't think he has poor taste. Most of what he's done is great. Again, I'm not into the sappy, like make you cry, break your heart kind of shit. I have enough of that in my own real life. I have enough trauma. I have enough, unhealed wounds. I have enough freaking SA and DV and abandonment and all kinds of stuff that I'm dealing with that, you know, I don't I don't particularly care for sad things, sad songs, sad movies, and really like stuff. It doesn't mean I never watch it. I do, but I cry very easily, and I'm an HSP. I'm a highly sensitive person, so it's um it's hard to watch that stuff. So I have to really be in the mood. I did start to watch 5 Feet Under, or 5 Feet Apart, the movie he did about the cystic fibrosis that was dedicated to Claire Wineland, who passed away. But I didn't finish it. Like, I'm like, I just don't want to watch a movie about two young, really, amazing people passing away. It's just like really hard. So, but again, he's willing to do the work. He's willing to tackle the hard topics and to try to make something positive, some positive change in the world. And he's consistent. And I think that all those people who could not stand him, like I saw some comments say, People who lack integrity cannot, and I'm paraphrasing, they despise people with integrity. They despise people who do the right thing. They despise, they cringe at this pompous guy who, like, actually has fucking morals. Again, paraphrasing. Why is he pompous? He's pompous because he cares about minorities. He's pompous because he cares about women. He actually cares about women, unlike Blake Lively and Colleen Hoover and Liz Plank, who weaponize and profit off of other people's suffering. All right, so I'm pull these last few pictures up that I wanted to show. So there you've got Liz Plank's page, Instagram. When was this from? This was from March 1st of 2022. There's Liz. There's Liz. There's Blatant Lie. Other marginalized communities at any stage in their career with a special focus on those who are trying to get their foot in the door in the entertainment industry at Van City Reynolds, that's Ryan Reynolds, offered to pay for the trainees out of his own salary and their housing during the hashtag Adam Project. So the magic of this movie is not just the dazzling performances you see on screen. Trust me, wear more waterproof mascara, but the radical diversity happening behind it too. Oh, really? Look at that radically diverse group right there. I don't know, maybe in the other rest of the carousel. I also got to see at Kate EV work her precious butt off on this initiative that she cared so deeply about, and seeing it expand its reach to help more marginalized folks give me so much hope about our industry. And don't get me, maybe somewhere in there she had tagged Blake, I don't know, but there they are. And also apparently she did an episode on something of Ryan's. So I guess that was enough to sell out her so-called friend. She was obviously a fake-ass, not real friend. Here's Sashti Fla, and her lovely boyfriend Magnus Sundholm. Somebody hacked into her Wikipedia page. Somebody made a very nice Wikipedia page about her, and then somebody hacked into it to smear her. What assholes. Go follow her. She's great. They're great. And Blake literally trying to. Here's Michelle. Okay, I'm not sure how you say her name. Michelle Trachtenberg. She was only 39 years old. Very tragic. She passed away. She had been on Gossip Girl. And so Blake shares a picture from Gossip Girl and saying this is the first day she met Michelle. And then to me, this is just proof of how disgusting she is. She talked about her yummy caramel smelling lip gloss. So are you sexually harassing this lady smelling her lips, you fucking creep, Blake? Like she wanted a nice experience for anybody who was in her orbit. Bitch, you sick bitch. This young, beautiful girl died. You haven't had anything to do with her probably since then. Apparently, Michelle had said on some post, somebody asked her about the Blake Lively, Justin Baldoni lawsuits, and she said, I'm dealing with real world issues. I'm not thinking about that. Shortly before she passed away. And Blake, so I've seen some people saying like, oh, Blake is using the word yummy, because she's trying to prove that that's part of her her daily vernacular. And I'm like, you can't after the fact. You know how evidence works? You can't say something after the fact of something like that yummy, spicy, never with teeth she's trying to do a BJ on Justin Baldoni text. You can't after the fact start saying something and then say, "Oh, see, this is how I speak." Like that's just nobody's that dumb except apparently some YouTubers. So anyway, I think she's a creep in every single way possible. You were smelling Michelle's lips. That's what you want to talk about? Like somehow you just want to make it about you and make it creepy. Like I feel like there's absolutely nothing that either Blake nor Ryan can ever do without it being creepy, because they are creepy to the core. You know how there's cottage core? They are creepy core. And that's my opinion. And with that, I will see you in the next one. Bye. Thanks for subscribing. Don't forget to hit like, hit share, hit the bell notification so you never miss a new video. I'm probably putting out videos 2 to 3 times a week, depending on how busy I am with my clients and other stuff. And I'm allowing myself to take longer breaks and to allow the videos that I do share to actually gain some traction and some views, because like I said, as of now, I cannot post a new video without it killing another video, so I might as well let the other video die before I post a new one. Anyway, if you like what I do and you'd like me to do more of it, then please subscribe. 88% of the people watching my videos are unsubscribed, but you're here all the time, so please subscribe, and I will see you soon. Ciao, my lovely peaches. Bye.
United States District Court Southern District of New York. Blake Lively, plaintiff. Wayfair Studios AV. Justin Baldoni, Jamie Heath, Steve Sarowitz. IT ends with U.S. movie AV. Melissa Nathan, The Agency Group PRLC. Jennifer Abel, Jed Wallace, Street Relations Inc. Defendants. Wayfair Studios AV. Justin Baldoni, Jamie Heath. IT ends with U.S. movie AV. Melissa Nathan, Jennifer Abel, plaintiffs. V. Blake Lively, Ryan Reynolds. Leslie Sloan, Vision PR, Inc., The New York Times Company. Defendants. 24 CV10049, lead case. 25 CV449, member case. Memorandum and Order Louis J. Lyman, United States District Judge. Consolidated defendant The New York Times Company, New York Times, moves, pursuant to Federal Rule of Civil Procedure 26C. For a stay of discovery as it relates to the New York Times pending a decision on its motion to dismiss. Dekate nomor 109. The motion is granted. A motion to dismiss does not automatically stay discovery, except in cases covered by the Private Securities Litigation Reform Act. Hong Leong Finance Limited, Singapore, v. 3/4/2025 Case 1. 24 CV10049 Aljol Document 118 Filed 030425 Page 1 of 5 Case 1. 24 CV10049 Aljol Document 118 Filed 030425 Page 2 of 5 Pinnacle Performance Ltd. 297 FRD 69, 72, Eston Y 2013. Quoting Moran v. Flaherty, 1992 WL 276913, at 1, Eston Y September 25, 1992. Upon a showing of good cause, however, the court may grant a motion to stay discovery pending decision on a motion to dismiss. See Federal R. Civ 16b, 4. Discovery schedule may be modified only for good cause and with the judge's consent. Fed. R. Civ 26c, d. See also Association Fe y Alegria v. Republic of Ecuador, 1999 WL 147716, at 1, Estoi March 16, 1999. Together. These provisions enable the district court to stay discovery where resolution of a preliminary motion may dispose of the entire action. A stay must be justified based on 1. The breadth of discovery sought and the burden of responding to it. 2. The prejudice, if any, to the opposing party of an order granting a stay. And 3. The strength of the motion. McSweeney v. Cohen, 2024 WL 4108539, at 1, Eston Y September 5, 2024. C. Brooks v. Macy's Inc. 2010 WL 5297756, at 2, Eston Y December 21, 2010. Bennett v. Cuomo, 2023 WL 2021560, at 2, Eston Y February 15, 2023. On January 31, 2025, Consolidated Plaintiffs Wayfair Studios, LLC Justin Baldoni, Jamie Health, It Ends With Us Movie LLC Melissa Nathan Jennifer Abel and Steve Sarwitz, the Wayfarer parties, named the New York Times as a defendant in their first amended complaint. Dekate nomor 50. The first amended complaint was served on the New York Times on February 7, 2025. Dekate nomor 73. On February 28, 2025, the New York Times filed a motion to dismiss the first amended complaint against it under Federal Rule of Civil Procedure 12b. 6. For failure to state a claim for relief. Dekate nomor 105. The New York Times' motion presents substantial grounds for dismissal, and the New York Times has made a strong showing that its motion to dismiss is likely to succeed on the merits. Cambridge Cap LLC v. Ruby has LLC, 2021 WL2413320, at 1, SNY June 10, 2021. Indeed, the Wayfarer parties note that their complaint may need to be amended to address the issues raised by the motion to dismiss. CDG. Number 117 at 3. 2 Case 1. 24 CV10049 Oval Document 118 Filed 030425 Page 3 of 5. The Wayfarer parties argue that discovery against the New York Times will not be voluminous and burdensome because it will cover a relatively narrow time frame. But the burden of discovery is not measured only by the number of pages the movement will be required to produce but also by the complexity of the issues that discovery will present and the sensitivity of the documents that will be requested. CEG Spinelli v. National Football League 2015 WL7302266, at 2, SNY November 17, 2015. Intricacy of contractual provisions and complex claims increases burden of discovery. B. Cis. And ELEC, Cis. Integration Inc. v. L3 Harris Cincinnati LX. Corp. 2023 WL4187489, at 1, SNY June 26, 2023. Fact that a significant portion of discovery will include sensitive information increases burden of discovery. Spencer Trask Software and Info. Serves, LCV, R Post International Ltd, 206 FRD 367, 368, SNY 2002. Risk of jeopardizing delicate negotiations increases burden of discovery. See also ECF No. 51 Flynn vs. Weissman, number 24 CV02409 VSB. SNY June 6, 2024. Staying discovery in defamation action based in part on the chilling effect costly discovery and litigation have on a publisher's First Amendment right to report newsworthy topics. The New York Times has indicated that to the extent discovery is sought against it, the New York Times intends to invoke its rights under New York's Shield Law. D. Number 109 at 2, see New York Civ. 79H. The reporter's privilege is intended to protect the public's interest in being informed by a vigorous, aggressive, and independent press. By limiting the circumstances in which litigants may obtain access to press files through court-ordered discovery. Chevron Corp. vs. Berlinger, 629 F.3d 297, 306, 07, 2 DCIR. 2011. Quoting Von Bulow v. Von Bulow, 811 F.2d 136, 144, 2 DCIR. 1987. The application of that law raises delicate and complicated issues which would increase the burden of responding to discovery. Moreover, the dimensions of the discovery that is permitted may vary depending on whether the New York Times is a defendant or a third party and 3 Case 1. 24 CV10049 Oval Document 118 Filed 030425 Page 4 of 5 Whether it was acting in a journalistic capacity or, as the Wayfarer parties allege, as a co-conspirator with the Lively parties. CDKD. Number 54. Baker vs. Goldman Sachs & Co., 669 F.3d 105, 108, 2 DCIR. 2012. Qualified privilege may be overcome by a showing, among other things, that the information is critical or necessary to the maintenance of a party's claim. Defense or proof of an issue material thereto. Internal citations omitted. Berlinger 629 F.3d at 307. Those who do not retain independence as to what they will publish but are subservient to the objectives of others who have a stake in what will be published have either a weaker privilege or none at all. Fowler vs. Ferry 2022 WL3211638 at 7-8, SDY August 9, 2022. Those issues will invariably be affected by the court's decision on the motion to dismiss. Finally, the Wayfarer parties are unlikely to be unfairly prejudiced by a stay while the court decides the pending motion. The New York Times did not delay filing its motion. It filed the motion within 21 days of being served. The court intends to address the motion to dismiss promptly after it is fully submitted. To the extent that the Wayfarer parties are concerned about delay, they have it within their power to accelerate their contemplated further amended complaint or their opposition to the motion to dismiss. The Wayfarer parties themselves suggest that discovery from the New York Times is unlikely to be voluminous. D. Number 117 at 2. To the extent discovery is sought from the New York Times as a defendant, it can be requested if and when the court denies the pending motion to dismiss. In the meantime, it is evident that the parties will be busy with document discovery from the other parties and with third-party discovery. Depositions are not anticipated to begin soon. The court hopes to decide the motion well before they do begin. For Case 1:24 CV10049 Oval Document 118 Filed 030425 Page 5 of 5 The motion to stay discovery as it relates to the New York Times is granted. The clerk of court is respectfully directed to close DKT. Number 109. So ordered. Dated March 4, 2025 New York, New York. Louis J. Lyman, United States District Judge.
Peach.com.
Fucking crook. I don't know.
CatLoveDreamingPeach.com.
CatLoveDreamingPeach.com.